All right, let's start.
Yes, sir, we can start.
Can I start?
Yes, sir. Yes, sir, you can start.
Good afternoon, friends of the media. I have an opening statement. I'll make that brief statement and then I'll take your questions. It is with deep regret that I address you today, my friends of the media, and through you, the people of India, on an issue that has assumed dangerous and monstrous proportions. My acquaintance with the law obliges me to be both frank in my views and restrained in my language. Governors appointed by the BJP since 2014 have repeatedly violated the letter and spirit of the Constitution of India. In the process, they have gravely impaired parliamentary democracy, its conventions and traditions. I may remind you that there are at least 3 landmark judgments of the courts when the governors concerned acted in gross violation of the Constitution in Arunachal Pradesh in 2016, in Uttarakhand in 2016, and in Karnataka in 2019. Despite these judgments and the statements of law, the governor of Rajasthan has stalled and continues to stall a perfectly valid request of the Council of Ministers of Rajasthan to convene a session of the Legislative Assembly. It is settled law that the governor shall act on the aid and advice of the Council of Ministers. The governor has no discretion, let me repeat, no discretion at all in the matter. The questions that the governor had raised to stall the request were irrelevant and beyond his authority. His current stand, that the law gives him a discretion to summon the assembly or not, is a complete distortion of the law declared by the courts. The fundamental basis of a parliamentary democracy is a functioning legislature. If the executive government wants the legislature to meet, it has the absolute right and authority to call a session. The governor is only a formal instrument, and I repeat, the governor is only a formal instrument to sign and issue the summons to the MLAs. If a chief minister who is accused of not enjoying a majority wants to prove his majority, he is entitled to call a session at the earliest to prove his majority. No one can stand in his way. Placing any obstacle to calling the session would undermine the fundamental basis of a parliamentary democracy. We are astonished and anguished by the attitude of the governor of Rajasthan. We are therefore protesting today before all Raj Bhavans in the country to highlight the gravity of the issue and draw the people's attention to the violations of the Constitution. We sincerely hope that the governor of Rajasthan will obey the law and only the law. He must remember that he has no other masters except the Constitution and the law. He must immediately grant the request of the Council of Ministers and summon a session of the Legislative Assembly of Rajasthan. I'm prepared to take questions.
Thank you, sir. I will request friends to please ask the questions. Rakesh Kapoorji, please go ahead.
Yes, sir. Good day, Mr. Chidambaram. My question is, yes, sir. If governor doesn't respect the decision of the cabinet, of his respective state government cabinet, then what is the remedy? And where is the remedy? Who should step in? Either the president or it is the central cabinet then where is the remedy, sir?
See, constitutional authorities function according to the law. There is a remedy. The Council of Ministers of the Centre, the Home Minister, the Prime Minister can send word to the governor, please call a session. Obviously, the President of India, the Rashtrapati, has the absolute authority to tell the governor what you're doing is wrong and please call a session. Now, I can only hope that the Rashtrapati will intervene in the matter and instruct the governor to call a session. If failing constitutional authorities, I don't want to come to any premature conclusion at this stage. If failing the constitutional authorities, then I think one has to explore legal remedies. But that is for the lawyers advising Mr. Ashok Gehlot to tell him what to do. I'm sure they are looking into the matter after the governor's latest communication, asserting that he has a discretion in the matter. Let me repeat, he has no discretion in the matter. Who did the governor? The governor should consult the Advocate General of Rajasthan. Has he consulted the Advocate General of Rajasthan? Can he place before the public any written opinion given by any competent law officer suggesting that he has a discretion to convene or not to convene? I don't think anyone acquainted with the law will give him such an advice. The law is very clear. Just look at Nabam Revia's case, 2016, Volume 8, Supreme Court Cases, page 1, and please see paragraphs 162 to 167 and 276. The governor has no discretion in the matter.
Thank you, sir.
Thank you. I'll move to the next question, sir. Sunil Prabhu wants to ask a question. I'll come to you, Sandeep.
Sir, I just want to know, you spelled out that there is the possibility of now, if the governor does not act, a legal strategy. But just want to understand the fact that, today you withdrew your case in the Supreme Court. You want to file a fresh case. It looks like, because in the light of the various statements and orders that have come from the Rajasthan High Court, what exactly, because there is a clear pattern. This has happened in Madhya Pradesh, in Goa, and in various other places. So what exactly is the Congress party in terms of a strategy wanting to do to save the Rajasthan government, or do you feel that there is no, that all these institutions, be it the role of the governor, the role of the center, and various other agencies will not allow you to and continue to give them the time that they require?
I don't want to get into the details, but I still believe that not all institutions will always fail. Sometime or other, they have to wake up back. There is a constitution in India. Now, I'm not advising Mr. Gehlot on the legal strategy. He has very competent, top-notch lawyers advising him, and I'm sure they will advise him on a legal strategy. I can only point out that I still believe that the President of India can intervene and instruct the governor to call a session. The law is very clear. It's in simple English. If you and I can understand, I'm sure everyone can understand. Yes.
Thank you, sir. I'll move to the next one. Syed from IANS.
Sir, regarding governor's position, do you think now there is a time to revisit governor's post and Congress should demand it, because all the governors are acting on behest of the union government as the party has alleged?
You see, what is the point of raising a larger debate about the usefulness of governors? Governors have their usefulness, but no one would have imagined that government would make them so useful to the ruling party. It's obvious that in Arunachal Pradesh, in Uttarakhand, in Karnataka, and in several other places, Manipur, Goa, the governors have acted simply as instruments of the political party ruling at the center, the BJP. It's one after another. I don't believe there has been a 5 or 6 year period when so many governors have violated the constitution. And there are 3 judgments which have come down on them heavily. What you are doing is wrong. What you did is wrong. In fact, they restored the status quo ante in one case. They directed the session to be called within 24 to 48 hours in the other 2 cases. Yet the governors, if a governor acts shamelessly, what is it I can do? I can only express my anguish and my astonishment. I still hope that better counsel will prevail and wise people will instruct the governor of Rajasthan that he must summon a session of the assembly.